Okay, thank you all very much for being here, and thank you also to our hosts for inviting us to speak to you this evening. So, not that one. Yeah, so I'm going to talk to you about some of the key aspects of UK employment law, and towards the end of it, it will also cover a little bit of visas in relation to that. So I apologize if this is not as entertaining as some of the earlier talks that we had. There was a lot of laughter. I feel I may have missed some of the jokes, but we'll do the best we can with employment law. Okay, so hopefully some of you may already be in employment, or you are looking soon to enter into the UK employment market. So I thought it would be useful to set out some of the key documents that you can expect to receive. Hopefully some of you have already got these, or when you start working. So in terms of the order that you would expect to normally receive these, it will start with the offer letter. Let's see if I can use that. Oh, brilliant. Yeah. So after you've gone through your initial application process, and no doubt that will involve interviews, sometimes an application form, depending on the company, you should receive this offer letter. That will contain some of the key details relating to your employment, effectively what your new company is willing to give to you. So salary, holiday entitlements, and perhaps some other benefits, if relevant, could be things like health insurance. It really varies from company to company, but it would be just the key features. Now, this may happen at the same time, but more normally, you would then receive, after you've accepted the job offer, the actual contract of employment. This then goes into a lot more detail, I'll circle it because I can, about all of your specific job duties, but also the relationship between you and the employer. So again, there will be details such as salary, but it will go into more details such as when you would expect to receive your salary, such as whether that's going to be weekly or monthly. It'll normally say, what day of the month even that you'll get it on. Likewise with holiday, you can expect that to be in more detail, including when in the year that will start and end, because it doesn't always just follow the calendar year. Your company's holiday year might, for example, be from starting in August, running through to the following July. So those are the sorts of things that you can expect to see in the employment contract. And then finally, once you start work normally, you would then receive the staff handbook. Now, in varying organisations, that may be known by other terms. Some places call it the employee handbook, some places call it the company handbook. But basically, it's normally quite a large document. It might be in paper, or it might these days more commonly be online, and it will contain all of the specific policies and procedures that are relevant to your work. So again, putting it in a practical context, for holidays, you would look at your handbook to see the policy in relation to how do you actually request a holiday from your company. So you probably find that there is a specific form that you need to fill in. It will probably say, how far in advance you need to request your holiday, and those sorts of things. Okay, so some key parts of UK employment law. So the first thing is we'll just discuss notice periods. Now this works both ways, of course. On the negative side, it could be if your employer is wanting to dismiss you for some reason, hopefully not. But also the other way around. At some point you may want to develop your career by leaving where you are and moving on into a different organisation. Now in the UK, there are basically two forms of notice. One is the legal minimum, which we can also refer to as the statutory notice, and the other is the contractual notice period. So very basically, the legal minimum is 1 week of notice for every year you've been employed. So if you've been employed in that company for 5 years, you're entitled to at least 5 weeks notice. Now, where the contractual side comes in, it's basically whichever notice period is longer is the one which will apply to you. So, if you are in a more senior role, it would be quite normal, for example, to have a notice period of, say, 3 months. So that would then be higher than your legal minimum, and therefore that's the one that applies. On the other hand, if your employer hasn't drafted the contract very carefully, and you've been there 5 years, but your contract still only says 1 month, you're going to get 5 weeks because that's your legal minimum. Now in the UK, it's very common for most organisations to implement a probationary period. Now, this doesn't really have a specific legal definition, but the way it's normally used is that it means for a set period of time, normally 6 months, basically a shorter notice period will apply to you. So this is this sort of 6-month probationary period is a chance for both sides to find out whether the relationship is working for you. Do you like working for this company? And from their perspective, are you any good at the job? And basically during that time, the notice period could be, for example, as short as 1 week. So that would be the only difference. After you've completed that probationary period, then your notice will go up to whatever it's supposed to be according to the contract. As I say, it could be 1 month, it could be 3 months, depending on what's been agreed. Now again, turning to the sort of less popular topic of dismissal, but more interestingly about what protections you have against dismissal. The key thing in the UK is that once you reach 2 years of employment with that company, you then have protection from unfair dismissal. Now, unfair dismissal. So, after that 2-year period is completed, a company has to have a particular reason to be able to dismiss you from your job. They can no longer simply say that they don't like you, for example. That's not a good enough reason. It sounds mildly amusing, but before the 2 years has completed, they could dismiss you just because they don't like you. So that 2-year period, you need to pretend to be nice and do all the things that they want you to do. After that, they have to fit any dismissal within one of the set categories. So, for example, poor conduct, or poor capability, redundancy, and a couple of others, but those are the main ones. And not only do they have to specify the reason within one of those categories, they also need to follow a fair process. So, for example, if we're talking about poor conduct, unless you've done something extremely serious, they wouldn't be able to dismiss you immediately. They'd have to go through a process of meetings with you, give you a chance to explain your side, and most likely give you a series of warnings before they got to the stage of dismissal. Now again, that is only once you reach the 2 years. Before 2 years, you don't have that level of protection. They can dismiss you. Now, something that you don't need to wait 2 years for is protection against discrimination. And that protection applies to you immediately once you start work, but potentially even before you start work, because the company is not allowed to discriminate against someone even during the application process, of course. And I've listed on there the characteristics that are specifically protected in law. Basically, if a company treats you unfavourably on the basis of one of these characteristics, then potentially you have a legal claim that you can bring. And that would include, if they dismiss you during that initial 2-year period, if the dismissal is due to a discriminatory reason, i.e. one of these characteristics, then you do still have that protection. So that's the added protection that you get in the exemption from the usual 2-year period. Now, the other thing that I'll mention in terms of being reasonably common in the UK employment sector, depending on what type of job you're taking, at the lower level, not so much, but once you start to progress in your career, or if you're immediately going in at perhaps a graduate level, depending on the role, you may find post-termination restrictions in your contract, which are sometimes referred to as restrictive covenants, same thing, just a different term. And these are there to protect the employer. So it means that, for example, if you leave the business, quite a common restrictive covenant that you'll see is that you can't take any of their clients with you for at least 6 months. So the idea is that if you've been in a key role and you've built up some good relationships with clients, the company's protected, because if you then leave, join a new employer, normally you won't be able to approach any of your clients and invite them to join your new company for a period of time. As I say, normally that's around 6 months, but it can vary. And it may not just apply to clients either, it can also apply to other key employees. So again, it prevents an employer from potentially being practically destroyed by someone leaving and taking all the best colleagues with them, all the best clients with them. So there's a bit of protection for the company there. Okay, so in the UK we have a few different types of employment. And I have to use the term employment a little bit loosely there in the legal sense, because as you can see, what we've actually got in terms of categories, effectively 3. So we've got our typical employees, which, if you like, is the normal category here. And as I've said here, it's the usual type, and that carries with it all of the employment rights. So the things that we've talked about so far, unfair dismissal protection, set a minimum wage, discrimination, etc. All of those rights contained for employees. That can include not just your typical full-time, permanently engaged individual. It can also include part-time workers. They can still be employees. And people on a fixed-term contract, also still employees. The second category is workers, and these tend to be in more casual industries, for example, delivery drivers or other zero-hour type arrangements. Some of the protections still apply, for example, minimum wage and some sick pay provisions, but things like unfair dismissal are not applicable. And then the final category for here is self-employed or independent contractors. This shouldn't be very common for most people, and it should be used really just for people who are genuinely self-employed, for example, consultants who may go from business to business. So do beware if a company is offering you a situation that describes itself as a self-employed or independent contractor, because some organisations will do that in order to try to avoid giving you the legal rights that you would be entitled to under particularly employees or even workers. So just be aware of that one. So visas for the UK, obviously there are a large number of potential visas, but in terms of those that are most likely to be relevant, we've got the Youth Mobility Scheme, which many of you will be familiar with. Gives you a 2-year visa for the UK. You can live and you can work in pretty much any organisation without needing to be specifically sponsored for that role. No minimum salary requirements or job skill level requirements, etc. And the graduate visa, which is quite similar in that it also gives you that 2-year period with effectively almost zero limitations on the type of work that you can do. So that's very useful for starting off your career in the UK. And then finally, the skilled worker visa on this page, which you could go straight into, or it may be something that you apply for after you spent a bit of time in one of the other categories, for example. For that one, though, you will need an employer who holds a sponsor license so that they are authorised to employ migrant workers. So finally, then, just a little bit about the skilled worker visa. There are minimum salaries for this role. The exact minimum can vary depending on the job type and depending on your age, whether you come out of a student category, graduate category, etc. And different jobs may have higher salary requirements depending on their seniority. Not all jobs can be sponsored for this visa, but it is significantly better than it used to be. It used to be a fairly restricted number of jobs that were capable of sponsorship, but we now have a lot more. So your job opportunities now in the UK market needing a visa are much improved compared with a few years ago. English language at level B1 is required. You will meet that if you have, for example, a degree that was taught in the UK. You won't need to do an English test. And after 5 years, you can be eligible for permanent residence or settlement in the UK, if that's something that you would be interested in. So that's all for them. So Q&A.
네, 질문 있으신 분은 손 들어서 질문해 주시면.
한국말로 하시면은 설명해 주실 거예요.
아까 인터프리터 할 수 있다고 그랬죠?
네.
네, 안녕하세요. 혹시 스킬워커 비자로 창업 가능한 편하신 분이가지고요.
스타트업.
네.
May I ask you, is it possible to start like business, like start with a skilled work visa?
A bit difficult with the skilled worker visa because the company that employs you needs a sponsor license. So if you're starting it up yourself, you'd need to have some sort of visa status already to be here. So that could be quite tricky.
만약에 회사에서 콘트랙트로 허용된다고 해도 그거는 된다는 거죠.
다른 그거는 그냥 스타트업 하는 거는 스킬드 워커랑 다른 비자로 생각을 하시면 돼요.
Hello, hi, Mr. Miles. Thank you so much for your presentation. And I was actually wondering, like, how much providing visa for a company to students is difficult, because I've seen a lot of friends that have to go back to their country because the companies, medical companies, were not willing to give them visas because of the money or like the time. And I really want to know the reality, like not the sugar-coated one.
Okay, yeah, sure. So I think one of the benefits that we have now is the graduate visa for students. So once you've completed your degree, you can apply for the graduate visa, which doesn't need a company to sponsor it. So you can just do that by yourself, and that'll give you the 2 years. So that's the first thing. Then in terms of visa sponsorship, as I say, not all companies can even offer it. They have to already be sponsor license holders, or maybe they'd be willing to apply for a license, but that's quite a lot of work. And then, yeah, if the company is supporting it fully, then there can be, quite a bit of expense for a company. So I think, the reality is that it's going to, and apologies that isn't super helpful, but the reality is that it's going to depend very much on what the job is. The more senior the job, the more useful it is to the company, the more they're going to be willing to support your visa. And also it will vary from company to company. Some companies will pay all of those fees and be very happy to do so. Others will say, well, if you want the visa, can you pay it? So it will vary.
And also, like, when I was applying for internship, I could see that if I have to check, like, do you need visa provided or not? But then I know I'm a student, so I will have 2 years of visa. But after the internship, hopefully I can get the full-time job. So should I tick the box, like, I need a visa in the future or not? Maybe if I don't say I need a visa, they will employ me more.
Yeah, I mean, yeah, it's a good point actually. Yeah, I'm being told discrimination at the front, and it's quite right. Technically, they should not be refusing people on the basis that a visa is required. They should be at least considering whether they should apply for a sponsor license. But as you mentioned, we won't sugarcoat it, so the reality might be a little bit different. I think obviously it depends on the exact wording of the question, you have to be honest, but if you have already got or you will be getting a graduate visa and the question asks, do you, i.e. now, need a visa, I would say no.
Thank you.
시간 관계상 마지막 질문으로 하겠습니다.
I just wonder if you have any specific condition that we need to carefully look at if we have, when we have our contract with the company.
Not really. That was short. No, I mean the key thing, in terms of your employment contract, the key thing really, definitely when starting out as well, is going to be, is the salary what you're looking for, is the job title and the job description what you are willing to do, and really, I think the contract is not where you're going to find problems. Really, where you will, if you're going to find problems, it will be once you've actually started work and you find the reality of the situation. Any company will normally have a contract that is quite heavily drafted to protect them, because probably they've paid a lawyer like 3CS to draft it to help them. So the contract will be quite focused on them. But the good employers that you want to stay with won't be strictly enforcing the exact terms of that contract. It should be a collaborative, mutually beneficial relationship. So I think the contract you can look at and understand. You probably won't have a lot of opportunity to negotiate it. So even if there is something that you really don't like, you may not have a lot of chance to change it. But I think in practical terms, you're not going to really have any issues until you actually start the job. And then either it's going to be fine and they won't be too strict anyway, or if they are insisting on every little term of the contract, it's probably not going to be great anyway.